My Lords, on this appeal I appear with my learned friend Mr Richard Munden. My learned friends Mr Jonathan Barnes, King's Counsel, and Mr Gervais de Wilde appear for the respondent. This is our appeal from the decision of His Honour Judge Lewis. I'm going to open the appeal and deal with all matters dealing with statutory qualified privilege and the respondent's notice. Mr Munden's going to deal with the point on malice.
Oh, I thought that I don't mind, in fact, I'm rather pleased, but I thought what you'd agreed, which we thought we wouldn't interfere with, was that you wouldn't deal with the respondent's notice in the morning.
No. I was just telling you who's going to do the advocacy on our side.
Oh, I see, not the order in which you were going to do it.
Not the order in which we're going to do it.
Yes, well, thank you, yes. So what's Mr Munden going to deal with?
Just the malice point.
Yes, I see.
Yes. This is an opportunity, we say, for the Court of Appeal to consider the Section 15 defence, the statutory qualified reporting privilege. And it's important to do so because, as we say, since the McCartan decision, subsequent cases following it have increased the protections for claimants and have recalibrated the defence, we say, unfairly for defendants. And the issue before this court is primarily one of statutory interpretation. And we not only identify the errors made by the judge below, but also how this court should approach the Section 15 defence, and in particular Section 15.3. And once it is properly interpreted, in our submission, summary judgment should have succeeded. Moreover, there's no arguable case on malice to go forward, and that should have been decided in the defendant's favour as well. On the facts, we accept as accurate the summary of facts by the judge below in the first 25 paragraphs, and we don't read any challenge to that on behalf of the defendant, but we accept as it's set out by the judge below. We also read into, from the respondent's skeleton argument, to what we say are concessions in respect of the judge's decision below. The first relates to the relevance to Section 15.3 of the state of mind of the journalist, and the second relates to malice. If I could just turn up the grounds of appeal, page 16 of the bundle. We say at ground 1C that one of the errors the judge made was considering the appellant's actual state of mind to be relevant to Section 15.3. It's the core bundle, my lord.
Yes, sorry.
Tab 1, page 16.
Which page are you on?
16.
16, yeah, thank you.
The first point is at C at the top, erred in law in considering the appellant's actual state of mind was relevant. And then at 2B, that the judge erred in law in considering at paragraph 93 of his judgment that there was a degree of overlap between the matters relevant to Section 15.3 and malice, which is why he considered that malice should go forward. In the respondent's skeleton, if I could just turn to page 67, on this, in paragraph 42 at the bottom, in the section headed malice, it states 3 lines from the bottom. There are passages in the authority, see for example Kadir and Al-Safi, that suggest a relationship or overlap between malice under Section 15.1 and questions of public benefit and public interest. But, as the judge recognised in substance, these are actually separate questions. Only malice bears on the publisher's actual knowledge and therefore state of mind. Well, we say that it's not that the judge recognised that in substance, because that is actually what the judge said, paragraph 93, page 100 of his judgment. First paragraph, first sentence of it, if I may, my lord, at page 193, the court will, however, need to consider that what the defendant...
Sorry. 193?
Paragraph 93 on page 100.
On page 100, yeah. Yes.
What the judge said is that the court will, however, need to consider what the defendant knew or should have known in respect to the allegations made by Ms. Sharif about the claimant when considering the test in section 15.3. It's not a case of understanding it in substance. That's exactly what he said. And it is we submit an error on the application of section 15.3 and what he thought he was doing.
Well, I don't think there's anything in the cases that says that suggests that the state of actual knowledge is the key under section 15.3, is it? Anyway, your point is neither actual knowledge nor imputed knowledge, what ought to have been known, has any relevance to section 15.3.
That is my.
You say that that's effectively conceded by that passage in the scope.
My lord, yes. And the second point is in respect of malice. To make this point, if one goes back to the grounds of appeal at page 16. At 2C, we say, as a matter of fact, the judge was plainly wrong in holding there was an arguable case of malice in respect of the first broadcast, because it was a live broadcast. There's no suggestion anyone knew what was going to be said by Ms. Sharif, and therefore no one could have a guilty state of mind in respect of the first broadcast. And we read the respondent's skeleton argument to be accepting that.
And you're accepting what? Sorry.
We appear, although it was run,
yes,
there is malice, it appears actually that they are accepting that. And it's page 69 of the bundle, my lord, paragraph 47.3.1.
47.1.
3.1. Said to be a red herring on the basis that a live report can't be a report, and therefore malice is a red herring in that respect. But what is actually, and the correct analysis, they say, is that a live broadcast, no question of malice applies. But the case as run was that there's an arguable malice case, and it appears to be accepted that there isn't an arguable malice case in respect of the third broadcast because it is a live broadcast, and it could have been said and made clear.
Talking of red herrings, I'm sure this is a red herring, given that I know less about this area than either of my lords. But can you just explain to me why there's even a publication by the defendant in relation to the live broadcast, having regard to the terms of 13D?
Well, publication under the Act takes its meaning under the common law, which is publication.
Publication by the defendant.
To any third
Of course,
party.
there's a publication, but why is it publication by the defendant?
Because it is the defendant who is responsible for that output.
Yes, but 13D says a person shall not be considered to be the author, editor, or publisher of a statement if he's only involved as the broadcaster of a live programme containing the statement in circumstances in which he has no effective control over the maker of the statement.
And in the context of Section 1 of the Defamation Act, which is an innocent dissemination defence, that is a valid consideration. But we are...
Sorry, I misunderstood.
The author, editor, or publisher is defined under Section 1, and the commercial publisher is responsible for their output. We are responsible for this output. We could raise a Section 1 defence in different circumstances, but we're not raising it here, and we're not concerned with it here.
Very well.
I accept everything Mr. Speaker said. It may assist if you look at paragraph 1 on page 3 of the authority.
Are you intervening on my point or on?
Yes,
or
just to help Mr. Speaker.
to help the right. Okay.
The defendant has to show he's not the author, editor, or publisher of the statement complained of. In this case, Mr. Speaker's position is that they are the author, editor, or publisher of the statement complained of, so they're not claiming for today's purposes that they benefit from the Section 1 defence.
Because publisher includes commercial publisher.
Commercial publisher, yes, that's right.
Yes, I see. Okay.
So that's the answer, I think, from Mr. Speaker.
My Lord, with those points made, I'm going to deal with section 15.3 and the first ground of appeal of failure to construe it properly. The section is at page 16 of the authorities bundle. The purpose of the defence is to protect the media as a reporter of statements of others, not as the media investigating and bringing material into the public domain that it decides or considers that the public should know. That is catered for under a different defence. And the purpose or intention of the statute is set out in McCartan and in Renwick, and it's set out in our skeleton argument at paragraph 16. I'm not going to take you there, I'm just going to drill down into what the words are and what is said. Starting point is subparagraph 1. The publication of any report or any statement mentioned in Schedule 1 to this Act is privileged unless the publication is shown to be made without malice. That is where the defence is. We say it's in the first subparagraph, because the words subject as follows matter. They identify the defence in section 15.1, and then they identify that the subsections following are limitations, qualifications, or exceptions to the privilege identified in subparagraph 15.1. And in order to identify the occasion, one looks to Schedule 1 of the Act for the various occasions. The one that is relevant here is a public meeting, but it's also a fair and accurate report of what is said in Parliament or in a court or such like. So we say that section 15.3 is, section 15.2 next is the entitlement in respect of a report or other statement mentioned in part 2 of the schedule, that there's no defence if the plaintiff shows the defendant was requested by him to publish a suitable matter or a reasonable letter and refused and neglected to do so. And section 3, the most crucial for our purposes, is the section does not apply to the publication to the public or a section of the public of matter which is not of public interest and the publication of which is not for public benefit. Under section 15.1, the defence is lost entirely if malice is found, so shown to be made with malice. Under 15.2, it's lost if the statement subject to explanation or contradiction is requested and not published. However, the publication of matter that is not in the public interest or not for public benefit does not mean that the defendant loses the privilege overall. Subsection 2 is a limit. It doesn't mean that the privilege is lost, as one sees from section 15.1 and section 15.2. And the reason we say this is that Parliament's decided in this regard that it's in the public interest for a defendant to publish a fair and accurate report of proceedings at a public meeting, even if what is said by someone is defamatory of another. That's the effect of subsection 1. And it would not be in the public interest to do so maliciously, and therefore the defence is lost. It's not in the public interest to do so and then refuse to publish a statement of explanation or clarification from the person demanded, and therefore the defence is lost in that regard. But it remains in the public interest and for the public benefit to publish a fair and accurate report of proceedings at a public meeting, including statements defamatory of someone, even if some matter that was said should have been excluded from that privilege and would not be covered by the privilege because that part was not in the public interest or not for public benefit. And therefore, given that it would remain a fair and accurate report would still be in the public interest, matter that's not in the public interest or not for the public benefit should be exceptional. We take that from both, as said, that it doesn't remove the privilege entirely as sections 15.1 and section 15.2 do, and the way that it is phrased, which is as a negative rather than as a positive. In essence, Sections 15.1 and sections 15.2 provide the defendant with a defence with important reputational protections, which mean the defence would be lost if they are not covered off. But section 15.3 doesn't. It provides a level of reputational protection in protecting against irrelevancies, or it provides a form of privacy protection. Because all of the heads of privilege in Schedule 1 refer to public occasions, proceedings in public in the legislature, proceedings in public before the court, documents opened by law to public inspection, and a public meeting. And the purpose, we say, of section 15.3 is to allow reporting of a public event identified in the schedule, but to provide some protection against private or irrelevant things said about someone on a public occasion. And what matters are in the public interest or are not for the public benefit must, we say, take their flavour from the purpose of the occasion. Which was a point raised by my Lord Justice Warby in the permission to appeal order on the first question. So if what one is dealing with here is a public meeting for the furtherance of public interest, public discussion, one looks at what that is and then checks the matter in dispute against that as to whether it has anything to do with the objects of the meeting. In considering the approach on section 15.3, the section refers to matter that has been published, not applied to publication to the public, but it's referring to matter which has been published to the public or a section of the public. So the focus should be on what has been published. It doesn't refer to what hasn't been published, but could have been. This was an argument put forward by the respondent below, that one should consider what the professional or conscientious journalist might have found out. But that's not what the section says. It refers to what has been published, not what could have been published. It doesn't refer to reasonableness, which does come into section 15.2 in respect of the letter. And it doesn't refer to what would be known by the defendant before publication, or what might have been found, or what might have been known if found out. Again, as I said, that's a point made by my learned friend below, and we can see it recorded in the judgment, is what could have been found out by a professional and conscientious journalist. And unlike Section 4 of the Defamation Act 2013, which is in statutory form the public interest offence, it doesn't refer to having regard to all of the circumstances of the case or the particular facts of the case. Which is something that the judge considered it did most directly in his reasons for rejecting permission to appeal. And it doesn't refer to the need or requirements for a further balancing exercise, because the section itself is a balancing exercise, as I'll come to demonstrate. So consideration of knowledge, subjective or objective, of the defendant, or consideration of all of the particular facts of the case and the wider circumstances of the case, are not within the statutory language. And if one interprets them to be so, one converts what is a reporting defence into a public interest defence to protect investigative journalism. And one can see that Parliament didn't go down this line because it chose to amend parts of the Section 15 defence in Section 7 of the 2013 defence. it made changes to public concern into public interest and amended the schedule. It didn't decide to include an all the circumstances clause because it's a different offence. But that is, as I will say, is the approach that the judge took below. And I would just identify what he said in his permission to appeal reasons for rejecting permission to appeal, because it comes out more starkly. It's at page 105 of the core bundle. And it's the second paragraph, my lords.
Yep.
And if I could just take you back, just to show you the distinction in these two defences, go back to the authorities bundle and to the 2013 Act, which is in tab 2, page 30.
Sorry, which tab?
Tab 2, my lord, page 30. You're very familiar with it. This is the publication on a matter of public interest offence, which was previously the Reynolds defence put into Parliament. Parliament's decision in this was that there should be a defence for an action for defamation if the statement complained of was or formed part of a statement on a matter of public interest, and the defendant reasonably believed that the published statement complained of was in the public interest. Therefore, the defendant's reasonable belief is squarely engaged. In fact, the defendant's subjective belief and the objective belief of a journalist in the position of the defendant is squarely engaged by 4.1b. And under 4.2, subject to subsections 3 and 4, which are not important for now, the court must have regard to all of the circumstances of the case. And when the media is acting as an investigator and bringing of its own will into the public domain information, it is right that if it is not going to bear the burden of truth, it needs to satisfy this test. But that's not the test under Section 15 of the 1996 Act, which is a reporting defence. But it is clear, we submit, that the judge was considering that it was, or that the defendant would have to get over those hurdles, such as a consideration of all of the circumstances, because that is what he said. If Section 15.3 required a consideration of the actual state of mind of the defendant, or the controlling mind of the corporate defendant, then firstly, it's not a reporting defence, and secondly, it would fulfil the same role as malice. And if it requires a res balancing exercise, which I'm going to go on to discuss or submit, it's applying an intense focus on the rights engaged, then it subverts the purpose of the section and recalibrates a defence that Parliament set out in law in 1996 and confirmed in 2013 by the limited changes it made, which were expansive. Final point on interpretation of this before I move on to the next ground is that we do say that when one interprets Section 15.3, it is relevant whether Section 15.2 was triggered. It makes no sense to us why this claimant did not engage on Section 15.2 when he had ample opportunities to do so. but where there is a means to enhance the information given to the public by requiring a defendant to publish a statement by way of reply, that must be taken into account when considering whether publication is a matter not for public benefit under section 15.3. That is a relevant consideration. This claimant had the opportunity, as claimants do, when it is an occasion of this kind under the particular part of the schedule, didn't take it. Judge doesn't take that point at all. He simply says at 33 that the right to reply was not taken up, but gives no weight to the existence of section 15.2 and the opportunity provided to a claimant when considering section 15.3. So
can I just ask on that specific point, because it's a development, and that assumes you've got a well-advised claimant. If that applied in every case, suppose you've just got someone who didn't know about this right, and the publishers themselves hadn't offered. I know you say you offered in this case and they didn't take it up, but why should that be relevant to what is the public interest and public benefit?
Because it's the section 15.2 part is there for a purpose, to give reputational protection to a claimant. If they can take it up, it will enhance what the public receives and the benefit to the public from the report. And therefore, it feeds into the question of section 15.3. It's a relevant consideration. Whether it is relevant in every case is a different question.
Well, that was the point of my question. I entirely understand that the right of reply is relevant to the construction in 15.3, but the idea that an ill-advised claimant should lose out doesn't strike me as particularly fair.
Well, I think it depends on the facts, but it was a point raised by my Lord Justice Warby in the questions in permission to appeal, and we say it's a good point. In circumstances in which there is a right to reply, it can benefit the public to receive that information from the claimant, and if the claimant doesn't take it up, it's a consideration on how to approach section 15.3.
Thank you.
And so we say if the section was approached properly by simply focusing on the matter that was published and simply questioning why, in these circumstances of a public meeting concerned with politics, concerned with an upcoming election, what one looks at as what was said is whether it's a matter of public interest, not for the public benefit. And we don't start looking into or interrogating states of minds of journalists or what could have been known or wasn't known or could have been found out and such like.
Can I just ask, if you're moving on, whether you have a submission about the burden of proof on this question, which may not matter, and if you don't have a submission about it, then fine, but it could have an importance for pleading in future cases. At the moment, I think the general understanding is that this is something that's a negative that has to be proved by the claimant.
Well, I have two submissions on this point.
It's not a problem.
The first is whether they are in fact, public interest and public benefit are in fact questions of fact. And a previous panel of this court in Kingshot held that these were questions of fact. Times newspapers were preparing in the McCartan case to argue that public interest should be a matter for the judge because it was nonsensical for a factual decision under that section, but for it to be a matter of law under Reynolds. And one can see that from Lord Cook's judgment in McCartan. And it doesn't make a great deal of sense, we submit to us, why public interest would be a question of fact under Section 15 and not under Section 4 of the 2013 Act. On the burden of proof, again, it's very hard to find clear statements on why the burden is assumed to fall on the defendant. One assumes it is because it is for the defendant to establish privilege. But the structure of the section, as we've outlined, would suggest it's for the claimant to bear the burden of an exception. Certainly looking in Bennion says the main significance of this form of drafting is to reverse the burden of proof. but it has been treated as a burden for the defendant, but it's not entirely clear from the authorities why. In terms of a proper approach, we would submit that these are questions of law, and that given the way that the section is structured, the burden should be on the claimant, as it is in respect of malice and as it is in respect of section 15.2. In the judgment below, the judge approaches section 15.3 as a means of protecting the claimant. It's paragraph 57 on page 92. He states that section 15.3 is an important part of the statutory principle, noting Lord Bingham in McCartan, the equivalent of section 15 as one part of the very considerable measure of protection put in place to balance the harm that might be caused to persons liable to be injured. Then goes on at 58 in respect of the need for the words public interest and public benefit are cumulative requirements, and then quotes from Mr. Justice Tugendhat's judgment in Kadir on how the court should approach 15.3. Kadir is a much later case, and it wasn't one of the protections that Lord Bingham was thinking about in McCartan. And I'm going to just, if I may take you to McCartan, which is at page 186 of the authority bundle. Tab 9, my lord. The issue was whether a report of a meeting was a fair and accurate report of a public meeting, being a press conference held in a rather grand private house. And it's a very liberal decision on both its interpretation of the law and on the facts. On what,
So, very what decision?
Liberal decision.
Liberal.
On what constitutes a press conference, and in particular its finding that a written press release not actually read out at the press conference was part of the proceedings of the press conference. It only has part numbering, but in the second numbered paragraph of Lord Bingham's speech, which is on page 200, he is recognising and explaining the purpose of the defence, that it is not an investigative defence, as I've mentioned, but it is a means by which statements of third parties on particular occasions can be published with protection. He starts off by acknowledging the cardinal importance of press freedom, and he's acknowledging here that the section itself is a balancing exercise between the purpose of the Act, which is to protect press freedom, but there are also built-in protections for reputation. When he does so, and I'm going to go through this, but when he does so, he's not referring to a res balancing exercise. He's saying nothing about the need to know all the circumstances, and he says nothing about the need to interrogate the state of mind of the defendant or of the reasonable person in the defendant's position, and nor does Lord Steyne, who gives the only other judgment. Lord Bingham is not making any of those points, but what he is saying, and he is referring to protections which are substantial, are as follows. The defence does not stop a claimant from suing the Speaker of the words.
Where are you reading from?
200 C. It's page bundle.
Yes, I've got page 200, but
C to D.
C to D. Thank you.
The privilege is not granted to the author of the statement complained of. That's the first protection. There is nothing stopping a claimant suing the defendant. In this case, there's nothing stopping this claimant suing Miss Sharif in Pakistan. Had he sued Miss Sharif in Pakistan, he would have been able to obtain, if he was successful, an injunction to stop her repeating the words complained of anywhere. As it stands, she's free to repeat what she wants because he didn't do that. But that's the first protection. Doesn't stop the claimant suing the speaker. The next protection is that the words must be spoken on one of the occasions Parliament has decided deserves protection, which includes a public meeting. And in response to a point my learned friend makes in his respondent's notice, the occasion has to be not only one which is set out in the schedule, but it only protects words spoken during the proceedings at any public meeting. So it doesn't protect discussions that take place before or after the public meeting, between security guards or the catering staff or anyone else. It only protects what is said in the course of the proceedings of the meeting. And if authority is needed on it, it comes from McCartan and Lord Bingham at 202 D to E. Paragraph, anything said by Mr. McKay to Mr. Wilkinson. And it's said by Lord Steyne, page 207, F to G. One looks at what is in substance the agenda of the meeting, and holding that since the press release was part of the agenda of the meeting, it formed part of the proceedings of the meeting. The next protection is that it must be a report or other statement. And this is a point...
Hang on 1 second. I'm just trying to understand the structure of your submission. So you're itemising protections.
I am.
So the first one was that you can sue the author.
You can sue the author.
The second one is...
Must be spoken on one of the occasions Parliament has decided deserves protection.
Yeah.
Must be part of the proceedings.
That's the third one, or was part of the second?
Part of the second, really.
Yeah. Okay.
It must be a report or other statement.
This is the third one.
Yes, my lord.
So I just want. So the third one is it must be
A report or other statement. That's the wording of section 15.
Yeah. Thank you.
This is a point taken against us in the respondent's notice, but we say it's plainly a report, and the judge's finding at paragraph 47 of his judgment is plainly a factual finding that he was right and correct to make. Next one is it must be fair and accurate about the claimant. This again is a factual issue, and the judge, we say, was correct on this in paragraphs 54 and 55 of his judgment. There's a right to reply in certain circumstances. On certain of the occasions, under section 15.2, there is the right to reply. That is another protection. It's a protection Lord Dennings, the Master of the Rolls, in the Boston case, thought was particularly important in Boston and Bagshaw. Do you want me to, I can take you to that if you...
Well, speaking for myself, I looked at my pre-reading, but...
there is section 15.3.
Sorry?
the next one, the next protection is section 15.3, and there is malice. And these protections for reputation are, we say, considerable, and they're more than enough. But on the judge's view below, the protection was greater because it was necessary to incorporate into the section a res style balancing exercise. And I took you to that earlier. And I also took you to what his view was in his permission to appeal notes about consideration of the wider circumstances and all the facts of the case. And these are additional protections over and above what we submit Lord Bingham was referring to in McCartan. To make this point, if I could invite you to go to Qadir at tab 11. Starts at page 227. The first aspect of the decision was whether section 15 covered an article reporting on the contents of a particular claim as a document open to public inspection. And the relevant paragraph of concern is at 100. I'll just take it back and start at 99. His Lordship says, in my judgment, section 15 reflects the need to have regard both to a public interest in freedom of expression and to the public interest that an individual's right to reputation is not interfered with, other than for a legitimate aim and when proportionate to do so. And we accept that, and we say that that is what Parliament set out and Lord Bingham was identifying in McCartan. But it goes on at paragraph 100, having identified what would be a general rule in respect of the publication of claim forms and such like. Halfway down is that the effect of section 15.3 is to give the court trying a defamation action the power and duty to consider a balancing exercise on the particular facts of the case. In effect, in that and the predecessor legislation, Parliament has required the court to carry out a balancing exercise similar to the one which has now become familiar under the HRA. And we say Parliament has certainly set out a balancing exercise in section 15, but not added an additional balancing exercise in section 15.3, similar to or the same as the intense focus test under Re S.
So you say paragraph 100 is wrongly decided?
My Lord, yes.
How would Qadir have been decided on the interpretation that you're advancing? I think you would say the existence of the defence would have to be ignored.
Well, one can see on the specific,
Or the acknowledgement of service.
one can see on the specific finding. The first point I would make on this is that Mr. Justice Tugendhat does analyse public interest and public benefit separately, which the judge below doesn't do. And on his finding on public interest, we wouldn't challenge that finding, that there's no public interest publishing a defamatory extract which omitted a statement that the claim is disputed. On the particular facts as identified, which is that you can't get the statement of claim unless there's an acknowledgement of service that has been put in. So we can see the force in that finding on public interest, which is at 101. We have more trouble with the finding on public benefit at paragraph 102, because his Lordship says at 102, in the present case, ANL is in a weaker position than it would have been in had it simply omitted to publish that the allegations were disputed. It misleadingly published that Mr. Qadir declined to comment. That suggests he was not disputing the very serious allegations which ANL were publishing There's no public benefit in publishing that misinformation. But that statement, he declined to comment, is outside of the privilege because it's not part of the fair and accurate report of the documents that were obtained. So properly analysed, we would submit that in principle there was a potential claim in respect of those words as troubled the Court of Appeal in Sakata, but they're not relevant for consideration of the reporting privilege. But that doesn't concern us on this case in particularly because the matter that is objected to here is squarely within the terms of the report. So the words complained of, or the matter that is objected to here about what's said about the claimant, there can't be any doubt that that is within the live broadcast. It's what Ms. Sharif said. The problematic aspect of this is that one cannot and shouldn't introduce an extra balancing exercise when Parliament has decided the balance. And we cite two Supreme Court decisions on this point. The first is MacDonald and MacDonald, which is in tab 13, page 291. The issue is very far removed from this case, is a court when entertaining a claim for possession by a private sector owner against a residential occupier should be required to consider the proportionality of evicting the occupier in light of Section 6 and Article 8 of the European Convention, said in the first paragraph of Lord Neuberger's judgment. And then it comes in again at 29 and 30. Where Lord Neuberger and Baroness Hale are just simply summarising the issues. Page 305 of the bundle, 29 and 30. And the answer, said to be a preliminary review, starts at paragraph 40. The key point we say is that what they decide is that Parliament has struck the balance, and that where Parliament strikes the balance, there's no room for considering Article 8 again. And at paragraph 46, of course, there are many cases where the court can be required to balance conflicting convention rights of two parties, e.g. where a person is seeking to rely on her Article 8 rights to restrain a newspaper from an article which breaches her privacy, or where the newspaper relies on Article 10. For such disputes arise not from contractual obligations made between the parties, but from tortious or quasi-tortious relationships, where the legislature has expressly, impliedly, or through inaction left it to the courts to carry out the balancing exercise. Sharp contrast to this type of case. Parliament hasn't left it to the parties to carry out the balancing exercise in respect of Section 15. It's been very clear in Section 15 what the balancing exercise is, what the purpose of the section is, and what the protections for the claimant are. Closer to home, the same point is made in Serafin, which is a libel action, and that's at page 365 of the bundle, which is tab 15. And this decision was considering the Section 4 public interest offence under the 2013 Act. And one can see at the top of 74, cites paragraph 47 of the judgment of the Court of Appeal when determining the issue whether defamatory material is published in the public interest under Section 4. The public interest in publication is to be balanced with the fact that the individual's Article 8 rights to reputation will be breached by the publication of unproven allegations without a remedy. And the court, Lord Wilson, says below, starting at F, for just as the common law defence was developed under the influence of the Convention principles, so was the statutory defence. Its three requirements: that the statement should have been a matter of public interest, that the defendant should have believed that the publication of it was in the public interest, and the belief should have been reasonable, all of which have to be established by the defendant, are intended and may generally be assumed to ensure that operation of the section generates no violation of either the claimant's rights under Article 8 or of the defendant's rights under Article 10. And one can take that is precisely what the 1996 Defamation Act did, and Parliament's amendments to it in 2013 indicate that it was untroubled, that it wasn't achieving a correct balance between reputational rights and freedom of expression rights. So we say that where Parliament has set out the test, there cannot be a duty on the court to add an additional hurdle. But even if we're wrong about that, then the judge didn't go on to consider, to direct him. He directed himself in that regard, but he didn't go on to consider a balancing exercise, in particular, the respective rights of this claimant and this defendant. And this is a claimant who was outside of the jurisdiction. And questions whether his Article 8 rights were engaged at all, because the claim form states he's in Karachi. So the court below was proceeding upon the assumption that very considerable protection needed to be given under Section 15.3. The way that the court interprets that is to include a res balancing exercise. We say that that's wrong, but even if that was right, if one looks at it on the facts, this is a claimant whose address on the claim form is Karachi, Central Pakistan. So he's not even in convention country or this convention country when one starts with the balancing exercise. Hence, on this ground of appeal, we say that the balance as set out by Parliament, as understood by Lord Bingham, has become more stringent over time, where one is looking at factors such as an intense focus test, states of mind of the individuals, all of the circumstances or the wider circumstances, what is or isn't known or ought to have been known. And it's problematic when one goes down that way because it allies a reported offence with a public interest offence. Further point on this is a point raised by my Lord Justice Warby in the permission to appeal questions about whether whether public interest and public benefit are cumulative or not. And we say that the judge firstly didn't differentiate between public interest and public benefit in his reasons for deciding that the Section 15.3 issue should go to trial. And one can see that from paragraphs 80 to 84 of the judgment. So we would submit that if a judge is considering this section and considering why it's not for public benefit or not for public concern, or it is arguably not for public benefit or arguably not for public concern, one should approach those issues separately. But this judge doesn't do so. We would say that a defendant only needs to show one rather than the other, that they're not cumulative. we accept the authorities in this regard are not very satisfactory. The first is an 1889 decision of Kelly and O'Malley, which is at tab 4 of the bundle. This is cited in Gatley on libel and slander as authority for the defendant having to prove both that the publication was of public concern and for public benefit. It's an action for libel against the publishers of a newspaper for the report of a public meeting. And it's concerned with a predecessor act, the Law of Libel Amendment Act 1888, which is in similar wording, and it is set out in McCartan if one wants, if your lordships want to see it. But insofar as the court says anything about public benefit and public concern, it's Baron Huddleston at the top of page 43 of the bundle in the second paragraph. Said the publication must be for the public benefit besides of public interest.
Well, that's him intervening in argument, so it's not authoritative anyway. But surely the actual point where he incorporates it in his judgment is halfway down the same column. This is actually halfway through after the second column. But it must not be published maliciously and must be of public interest and benefit.
Yes, and that's the second reference.
Yeah, but that's, I mean, it's obviously helpful to look back at what he said in argument. It's slightly more explicit, but actually this is the authority, not the intervention in argument.
Insofar as it says anything, it doesn't say very much. There's no reasoning on the point or any consideration of why, if he's come to that interpretation, why he's done so.
He's just following the words of the Act, isn't he? The Act says and.
That's all that's said. You also said that Boston and Bagshaw doesn't assist either, which is the other authority cited in Gatley.
Yep.
Just take the Master of Lord Denning said, well, your lordships have said you've read it, but
No, if you want to take us to it, do.
yeah, it's at page 51. Again, this is about the TV broadcast of a statement by a chief constable about the reward for the recovery of stolen pigs. And the Court of Appeal held that the broadcast was covered by statutory privilege. Lord Denning holding that it was a matter of public concern and public benefit to give information to the public in trying to find a criminal. Very clear on the subject that nothing about the burden. He's very clear on the subject that it's a matter of public benefit and public concern, but he
Sorry,
sorry.
Which page?
Page 51.
But where were you reading from? Which
Starts at E. The submission put that Mr. Hurst argued that.
Yes, I see. Thank you.
The crime was too small to be a public concern. Seems to be in the argument.
Yep.
Yep.
But insofar as that is cited as support in Gatley as well for a cumulative approach, it doesn't provide, we submit, anything of value on this particular point, on the point of whether it is cumulative or not. What we say in the skeleton argument is at page 35 of the core bundle. in response to the question raised was whether the defendant shows that neither applies as apparently suggested in Kelly or in Malice.
Sorry, again, I'm on
I'm
page
so
35,
I'm sorry.
but whereabouts?
I'm so sorry, my lord. If I may start just at the page before on 34, the question of are the two exclusionary criteria cumulative?
Yes.
And our submission on this point is at Roman 4 over the page, that we submit that the wording of the statute should be given its natural reading, that sufficient for a defendant to avoid losing the privilege to prove either the subject matter was of public interest or...
Yeah. But I mean, going to the authorities isn't really the point. What you just sort of you've got to read the words and how they're structured.
Well, the reason why this point is raised is because in the leading textbook on the subject, it cites the authority.
Well, I dare say, yes, but I mean, in terms of submissions, I'm not saying you shouldn't take the point, and my lord obviously raised it. I'm just, if you actually look at the wording, it does not apply to the publication to the public of matter which is not of public interest, and the publication of which is not for the public benefit. If you can't show both of those, or I don't want to take a point on the burden of proof, but if both of those apply, then section 15.3 is not engaged.
Well,
isn't that the right way?
You have our submission on it, which is it hasn't been considered particularly carefully in either of the two judgments that are cited as support for it. We would submit that you can, that if you have to look at it cumulatively, it is a more significant test for the defendant, particularly if the burden rests upon the defendant as well. But it doesn't have to be read that way. And the natural reading of it wouldn't be. But we answered the point we were asked.
Yes, I wasn't taking put into your particular view. I was simply saying we don't need to look at all this authority. You just sort of parse it as a matter of English.
Well, that is what I've been trying to do with
the
section overall.
It's quite surprising that after, I haven't done the maths, but about roughly 140 years, nobody's actually addressed it squarely, except Baron Huddleston.
No one has.
It may indicate how insignificant it is in the grand scheme of things.
Or how obvious the answer is.
Well, there you have it. We thought we'd make that point. Moving on, grounds 1, C and D concern the states of minds of the journalists, and I have addressed you on this already, that there is nothing in section 15.3 that states a need to consider the states of minds of reporters. And we identify what we submit were the confusions in the judgment, because we set them out in the skeleton argument, which is on page 26 of the core bundle. At paragraph 32, that at 58, his lordship said that the report had been published on a matter of public interest and for public benefit was to be decided objectively, and at 83, that the publisher of a fair and accurate report did not need to fact check. Yet at 73, he's saying there was a clear dispute to the extent to what the defendant knew or should have known that the allegation being made by Ms. Sharif was disputed. And at 83, that there's a question of what was known or arguably should have been known by the defendant. And at 93, the court will, however, need to consider what the defendant knew or should have known in respect of the allegations made. And we say that belies a confusion as to whether there should have been a subjective or objective test under section 15.3. But our primary submission is it shouldn't have been either, but it certainly shouldn't be subjective. And the judge below seems to be in confusion as to what the state of mind of the journalist should be under section 15.3. And again, having made these points, the question of what was known or ought to have been known does not appear within the section. And there's a good reason why we'd say is because what matter, and matters the word under section 15.3, the public would benefit from receiving, is different to what the defendant thinks about communicating it. Does it matter what the defendant thinks should be communicated? The question is what the public would benefit from receiving. Likewise, whether it's in the public interest for it to be published is separate to what the defendant's belief is in respect of whether it's in the public interest. And whilst that's squarely engaged in the section 4 defence, it's not mentioned here. So the test cannot be, we say, both subjective and objective. And there can't be any support for a roving inquiry into what the defendant knew or should have known. And as I started these submissions with the point, it appears we submit that the respondent is now accepting that in the skeleton argument. Because whilst they tie their concession to confusion in authorities below, saying that the judge in substance understood this, the judge quite clearly in those 4 paragraphs that I identified is referring to both subjective and objective knowledge in the context of section 15.3 and malice. And even if we're wrong on our interpretation of section 15.3 about what is admissible to consider the matter which is of public interest or for public benefit, it simply can't be both of those things. So, I mean, that is the ground of appeal that I identify first off, that not only is it too high a test to meet, but one can't be looking at 2 different states of mind. Which leads to the question of why did the judge reject summary judgment on the question of 15.3, and one can see that in the judgment, page 98 of the bundle, paragraph 81. The section on section 15.3 begins earlier on page 92 at paragraph 57. And just on a point, my Lord Justice Underhill made it, the issue as it's set out is, was the publication of the words complained of public interest and for public benefit? And we submit that's the wrong way round. because that's not actually...
So sorry, where are you reading from?
The words above paragraph 57.
Sorry, 57.
Yes. It's the wrong way round. That's not actually the wording of the section. The section is in the negative.
And there's also a misquote of the section, which talks about matter, not publication.
Yes.
So it starts with matter and then it talks about publication.
Correct. He's not the only judge to put the question this way, but I think it's best put actually by Lord Justice Ward in the Cicata case, because he...
By the way, my lords told me beforehand there's a correct pronunciation for cicada. I can't tell you what it is, but my lord...
Chickata was what I was told by somebody who knows better than I do, but I can't vouch for it being correct myself.
I'm afraid I'm never going to get it right. Well, I know it.
It sounds more West African, the other one sounds more Japanese.
Lord Justice Ward does ask the question the right way round in the negative. I hope he doesn't refer to the words complained of, but he asks, his Lordship's bang on. Is this a publication of matter, quote, which is not a...
Sorry, where are you reading from?
I'm reading from Cicata. The internal paging is 670.
What's the page in the bundle?
It's covered in black, I'm afraid.
82.
82.
And by the side letters, whereabouts are you reading from?
D.
Sorry?
D.
D.
The italicized question below D.
Yeah.
Sorry. 81, did you say?
Page 82.
82.
670 at the top,
Thank you, got it.
and he
Yeah.
just quotes the statutory wording.
I would submit that's the way to ask the question.
Yeah.
And if one asks the right question, one is likely to get closer to the right answer. But if one asks the wrong question and then starts the section by referring to the protections, the very considerable measure of protection that one gives the claimants, one starts off on the wrong way of approaching section 15.3, which is what happens here. The wrong questions asked. We then have the very considerable protections. We then have the Qadir consideration, including the way to approach the section, which includes the res balancing exercise. There are then a series of quotations from cases which do not concern public meetings. And it's not entirely clear from the paraphrasing of some of those judgments as to what point is actually taken from them on section 15.3.
But this long section here isn't really the heart of the matter. The heart of the matter, why he refuses summary judgment, is really only apparent from 81 to 84.
And that's what I'm coming on to.
All right.
That's where I am. But in just getting to that position, what one has is the way that the question is asked, which is wrong. One has a series of extracts of cases where it's not entirely clear what the point that is being taken from the particular case. And then the two reasons that are given for considering this is a matter for trial are first at 81, the status of the information, and second at 83, the question of what was known or arguably should have been known by the defendant. In considering...
There seem to be 2 points possibly within the status, under the status heading, one is at least 2 points, perhaps. One is the status of the event. The proceedings, because they were a rally outside the UK which didn't have the legal protections that would obtain here. That's the focus, I think, of paragraph 82. And the other is the status of the information, which is identified as, well, the gist of the allegations is identified in the expressive and extreme language used to convey them. That's in paragraph 81.
I agree with that, and I'm going to deal with each of those points. First point I'd make, however, is that he doesn't differentiate between public interest and public benefit when looking at the status of information. He does go on to explain that Ms. Sharif used expressive and extreme language, and we address this in the skeleton argument at paragraph 36 on page 27 of the bundle. First point we'd say is that there's nothing wrong.
Sorry, which paragraphs do you say in the skeleton?
37.
Thank you.
We start at 36 with the first stated reason was said to be the expressive and extreme language used by Ms. Sharif. But he doesn't explain what's meant by expressive. What he appears to mean by extreme is that the speech consists of making defamatory statements about the claimant. Now, we say that there's nothing wrong with a politician being expressive, and not least because this judge accepted as much earlier in his judgment. Because if one looks at paragraph 42 of his judgment, he is considering why this is a public meeting. And he says at 42, I'm satisfied that the rally was a public meeting for the purposes of paragraph 12 of the schedule, and I don't think the claimant has a realistic prospect of demonstrating otherwise. And he says at 1, because it's an important political rally, because it's a genuine public, page 89, the address was given by a senior figure, organised in advance, nothing private about the event, and F, there's no need for the event to be balanced with speakers of more than one political viewpoint. There was always also no need for the meeting to be conducted with decorum. Political debate can often be highly charged and confrontational, but this does not of itself remove a public meeting from the protection. So we come back to question, what is it that is wrong with a politician being expressive? And we would say nothing in respect of that.
Or more accurately, what is contrary to the public interest or not for the public benefit to report a politician being expressive? That's what we're concerned with.
Yes, yeah, absolutely. That is the key point. So we don't consider that is a justification or a reason. The next point, he's also made findings in respect of the rally itself. So my Lord Justice Warby was referring to the information, but also the status of the event. The judge below has made findings that this comes within the statutory definition of a public meeting. In that regard, in respect of proceedings being outside of the jurisdiction, Parliament expressly expanded the public meeting paragraph in the 1996 Act, in the 2013 Act. Sorry, that was muddled. But in the 2013 Defamation Act, Parliament expanded protection to public meetings anywhere in the world. That was one of the amendments it made in 2013. consequently to say that there should be some different test outside of the jurisdiction when Parliament has decided that public meetings outside
That's not really fair to the judge. His point may or may not be good, but he's not saying there's a different test because it's abroad.
I accept if that's my phraseology is unfair, but we don't accept that the fact that it is outside of the jurisdiction is a matter of relevance to section 15.3 on either public interest or public benefit. And we've made the point that we have in respect of the expressive nature of the language. We make a factual point in the skeleton as well that even if there is any justification for a geographical dependent approach, this is not a case for it, given the substantial audience of British Pakistani and Pakistani citizens here with strong and legitimate interest in Pakistan and its political life. That's paragraph 40, subparagraph 4. So we don't say that is a good point on the law, given what Parliament did in 2013, and we don't say it's a good point on the facts of this case. And insofar as status of the information, Sikata is a very different case, being a case about a special inquiry by a judge into the murders of 3 judges, and it's a different head of privilege. The public know what they're getting at a public meeting of this kind, and weigh that accordingly. But one can't look to how a judicial inquiry takes place and say that if only all meetings or rallies took place in the same way, that would be the only way one could get privilege under a public meeting occasion paragraph. Can't be right, because otherwise he doesn't even consider it to be right in his findings on public meeting, which we say are correct. So we say that when one looks at the first reason for refusing, considering that the issue of section 15.3 should go to trial, on the state of the information broken down, there is nothing that should have engaged section 15.3 on either public interest or public benefit. And the second reason the judge gives is at paragraph 83, which is it's the question of what is known or arguably should have been known by the defendant. And I've been through that in considerable detail. It's not explained why that's relevant to public interest or to public benefit, and on a true interpretation of the statute, it's not relevant or admissible. The other point, sorry, to go back to the paragraph 81, that the fact that he was raising allegations that were clearly highly contentious, well, the answer and the protection for the claimant in that position, as identified from going through the list in McCartan, is first you sue the speaker, and secondly, you have the ability to make a right to reply under section 15.2. That's exactly what Lord Denning said in the passage I took your lordships to in Bagshaw. I think I'm just going to go back there, if I may, to tab 5. At page 51 of the bundle. Having considered that it was for public benefit, having addressed the not not of public concern and not for the public benefit question, at G, it is no doubt possible that on some occasions innocent people may suffer from what is said, but the misfortune which an innocent person must endure for the sake of the public good, he can immediately ask for an explanation to be given and the position made clear. That's the primary protection for contentious claims, because the defence protects the reporting of defamatory speech by another. And
that protection isn't there for Schedule 1, Part 1 reports, so it can't come into the public benefit assessment in that context.
But it can come into the public benefit assessment in the second set, and but the point of the matter, just on the judge's reasoning, it can't be problematic that one is raising allegations that are contentious, and it can't be problematic that one's raising allegations that are defamatory, because the whole point of the defence is to protect the reporting of defamatory speech by another. And that, by its nature, is going to be disputed and is going to be contentious, or there would be no need for the defence. So we submit that when you understand that the purpose of the defence is to protect defamatory speech by another, which is bound to be contentious or disputed, the protection, certainly in relation to a public meeting that is given, the best protection given is you can sue the speaker, or you have the ability to require a right to reply to be published under Section 15.2. What you can't do is overload Section 15.3 in the way that it is, we submit, being done here. That's not the purpose of that exception to the defence under Section 15.1. It can't possibly be because defamatory allegations are highly contentious that they don't come within Section 15.3. Otherwise, there's no need for the defence. And one can't look at the status of information at a public meeting in the same way as one looks, as the judge did by citing Cicata, as a judicial inquiry. He was right at paragraph 42 when he looked at why it was a public meeting for the furtherance of public discussion. Just on the point that was raised about, and I touched upon, about the meeting being overseas as one of the three considerations, we address this in the skeleton at paragraph 40 on page 28. In a slightly more organised way than I submitted earlier. But the first is that the Defamation Act 1996 does not draw such a distinction as it could have done. There's no case law to support a distinction. Cicata concerned matters outside the jurisdiction and the privilege was upheld. All three judges of the Court of Appeal found Section 15.3 met in respect of publication outside. The obiter comments of Mr. Justice Eady and Crossley don't take the matter forward, simply pondering what might be the position with an overseas court report, but he hadn't heard any argument on the matter, and it was prior to the 2013 Defamation Act, which extended the scope of a public meeting paragraph, and there's no justification for a geographical dependent approach in this case. And so we say that the two reasons given by the judge simply don't, under analysis, impinge upon section 15.3 or meet the negative test. And we do set out at paragraph 47 of the skeleton points of particular importance in this regard. 47 first is, there's no dispute that this is a subject matter of a broadcast, was a political discussion and the perceived failings of a former Prime Minister during his time in office. That's the finding at 42. And we say, the judgment, we say that these are words complained of relate to politics, which is the highest form of protected speech. And it's what one politician was saying about the relationship between another politician, former Prime Minister, and the owner of a TV news network. This comes, and this is election time, and this comes squarely within the definition of public interest by Lord Bingham in the Reynolds case in the Court of Appeal, which was approved by the Supreme Court in Flood 47.2. Public life activities such as the conduct of government and life, elections.
If you're just simply reading out your skeleton, do you not just want to tell us which passages you want to read?
I mean,
we've read it already.
I'm very grateful.
I'm just not sure.
Then what we say on this point, and I will just summarise very briefly, is that there is a public interest both in respect of the discussion of politics, and that is a public interest. There's no dispute about that. There can't be. This country had a public inquiry into the relationship between politicians and the media. Squarely sits within the subject matter of public interest, and it's and on the issue of not for public benefit, hearing a fair and accurate report of what a politician says about an opponent informs the audience how to vote and how to discuss these matters. And you can look at that either way it comes to it, either in respect of what is said about Mr. Khan by Miss Sharif, or what you think of Miss Sharif because of what she's saying about Mr. Khan and the claimant. One can see that very clearly in the current climate in respect of the US elections. It informs and benefits the public to hear what the candidates are saying about each other. Because you might not take on board what the individual says about an opponent, you might well think that having heard them, they're unfit for things. So either which way you look at it, it is unquestionably for the public benefit for them to hear a live broadcast of that kind. And the subject matter is unarguably in the public interest. The subject matter is unarguably the reason why the public meeting took place in the first place. And that's why, properly analysed, the judge should have entered summary judgment on the issue of the privilege. My Lords, unless you have anything further on the privilege, I'm going to let Mr. Munden address you on the point of malice.
Thank you very much. Yes, Mr. Munden.
Malice. There are three grounds of appeal on malice, which are in the appellant's grounds at pages 16 to 17. I will take them in that order, first addressing 2A and B together as to the errors in the judge's brief reasoning for allowing what he acknowledged was a weak and problematic plea to go forward. And then ground 2C, which is essentially what should have happened, and on any proper analysis, there is no proper basis on malice.
So let me just be clear about that. You're taking 2A and B together.
Yes.
And then 2C separately. Very well. Yep.
The judge starts his consideration of malice, paragraph 85 of the judgment, which is page 99. And he there sets out a statement of the law from Mr. Justice Nickbin in the Huda and Wells decision. And there's no dispute that is an accurate and appropriate summary. The paragraph numbers disappear halfway through this quote. So it is perhaps easier to look at it in the authority itself, which which is tab 14 of the authorities file, page 337.
Yes, thank you.
So beginning at paragraph 70, he starts by saying malice means publishing a statement the defendant knew was false or was reckless in the sense of complete indifference as to its truth or falsity. He then refers to Alexander and Arts Council and Horrocks and Lowe. He talks about, in paragraph 71, he refers to the dubious nature of dominant intention and dominant improper motive in respect to the qualified privilege defence, which is a point that he has developed in the Harkin decision, which I'll come to shortly. Paragraph 72, very importantly, he quotes from Mr. Justice Eadie's decision in Henderson and says that malice is a serious allegation, the equivalent of fraud. It must be pleaded with scrupulous care and specificity. It's quite inappropriate to proceed on the basis that something may turn up, whether on disclosure or at trial. At 73, he makes clear that each of the particulars relied upon must be more indicative of malice than its absence, more consistent with the existence of malice and with its non-existence, quoting Turner and Tellenthorpe. And then at 74, this is a passage that didn't make it into the judge's judgment, but was put to him. The court will scrutinise the statement of case in order to discern whether the malice plea has any prospects of success. Going back to the judgment, at 86, the judge then quotes Mr. Barnes' submission for the claimant. And Mr. Barnes' submission was that it was premature to evaluate the strength of any plea of malice, because we haven't had a reply, we haven't had disclosure, and we haven't got to trial. That is a submission that the judge succumbed to, but it is in our submission obviously wrong, given the law that is set out in Hooder, and in particular the quote from Henderson about not waiting to see if something turns up, and the quote from Turner about each particular needing to be more consistent with malice and with its absence, as well as paragraph 74 about the court being required to scrutinise the plea of malice.
Well, those passages refer to each particular, which assumes a pleading.
Yes.
And quite typically in cases of this general type, there's at least a defence, and quite often there's a reply.
Yes.
So
We are...
Is the striking out or the summary judgment here premature for that reason?
My Lord, no. In our submission, malice is a matter that has to be... The claimant has to have a case on malice at the pleading stage, so prior to disclosure, prior to evidence, prior to trial, and must be able to set it out. And it does not matter whether it's being set out in a witness statement or in a pleading. If authority is needed for that, Mr. Justice Eadie addressed this point in Serre, Warby and the Charity Commission, which is tab 10 of the authorities bundle, page 223, where he, paragraph 33, where he referred to the requirements applying whether in a pleading or in a witness statement. Paragraph 33. He said it's necessary to have regard to the principle explained in the older case of Somerville and Hawkins, that is to say, the facts relied upon by a claimant, whether in a pleading or in a witness statement, must be capable of giving rise to the probability of malice as opposed to a mere possibility. And this was a summary judgment application. There was plenty of time for the claimant to draw together strands and the particular facts and matters on which he wished to rely in a malice plea. The onus was on him to set out a proper case, if he had it.
There's reference in the evidence to a letter which is said to set out the building blocks, but I don't think we have the letter, is that right? 22nd of November.
We don't have it.
No, we don't.
The letter has been developed and is in more detail, both in Mr. Packard's witness statement and now in my own friend's skeleton.
Yeah, but that's what I assumed. There was nothing additional
No.
in the letter.
In fact, there's a lot more in the more recent expositions of the malice plea than there was in the letter. In any event, Mr. Barnes no longer seems to be pushing this line, because in his skeleton argument at paragraph 43, he says he doesn't need to wait for anything to turn up. His malice plea can be evaluated now. But we say the judge was quite wrong to essentially allow the case to go forward on the basis that something might turn up. At 92 in the judgment, the judge considered the criticisms that we made of the case of malice insofar as it's been advanced.
Sorry, which paragraph are you talking about?
Paragraph 92, back in the judgment.
Yep.
As already noted, it's difficult for a claimant to prove malice in response to excess qualified privilege. I acknowledge it is not immediately apparent on what basis some of the matters identified in paragraph 87 above, and that is the judge's summary of the malice plea, which we'll come back to. Not immediately apparent on what basis some of these matters would be applicable in this case. And many of the points made by Mr. Moses about the claimant's case on malice are good ones. So he acknowledges there are at least problems with the claimant's malice plea. But rather than following that through and ascertaining whether or not this is a viable malice case or not, he decides to allow malice to go forward on the basis, paragraph 93, that the court will, however, need to consider what the defendant knew or should have known in respect of the allegations made by Ms. Sharif about the claimant when considering the test in section 15.3. Now, Mr. Speaker has addressed you on this, but it is accepted on the other side that actual knowledge is only relevant to malice. There would not, contrary to the judge's suggestion, be any investigation at trial as to what the defendant knew on the test of section 15.3. It is a separate question, quite a separate issue, and it should not have been bundled together in this way. What the judge has effectively done is said, well, maybe something will come up on 15.3 that might assist malice plea, and that was not correct. He was quite wrong to do that. It was also quite wrong of him, and directly contrary to the law set out in Huda, to simply decline to scrutinise the case as put forward and assess whether it was valid or not. As I say, at 92, he gives some pointers to say he doesn't think it's particularly strong, but he doesn't go on and assess whether it is good enough. And those are grounds 2A and B. He ought to have assessed the viability of the case as it stood. And his decision to elide malice in section 15.3 was quite wrong. I should say, in addition to the claimant respondent, Mr. Barnes, accepting that only malice bears on actual knowledge, he also rightly accepts that section 15.3 is wholly objective, so they are distinct and separate, so there's no overlap there. That explains what the judge got wrong. If we move on to ground 2C, this is where we say, had the judge carried out the proper exercise, he would have ruled that the case being put forward was inadequate. Again, there's been helpful concessions made in Bernard Friend's skeleton argument, to which Mr. Speaker referred earlier, which was that the case in malice was being put in respect of both the live broadcast and the subsequent headline packages. And that was always nonsensical when nobody knew what Ms. Sharif was going to say before she said it. It is now accepted that there isn't a case of malice being put forward in respect of the live broadcast, but only the later packages. But he does maintain his case on those later, smaller broadcasts, and so we need to assess whether or not those are put forward any viable case. I'm going to structure my submissions on this part in 4 parts. The first part is that since the judgment of HHJ Lewis, we have had the decision in Harkham and Associated, which has made clear that the only relevant form of malice in a reporting privilege case is actual knowledge of falsity.
Sorry, actual knowledge of?
Of falsity. Actual knowledge that the words being reported are false. Dominant improper purpose is no longer relevant. And of course, the claimant's original plea was directed very much at proving dominant and proper purpose. The second aspect of the submissions is that the claimant's response to this, that HHJ is immaterial because he has a case on malice akin to Qadir, is quite wrong.
Akin to?
Qadir, the Qadir and associated case that we've already looked at briefly. We say he's quite wrong about that. That was a very different case. The third aspect of the submissions is that insofar as the claimant's case does address actual knowledge of falsity, it's plainly insufficient.
Sorry, again, what was the third one again?
It's insofar as his case does address actual knowledge of falsity, it is plainly insufficient. And then fourthly and alternatively, if the court declines to follow HHJ and holds that Horrocks and Lowe, dominant and proper purpose, applies to reporting privilege as well as to common law qualified privilege, then we say the other factors that the claimant seeks to rely on don't add up to anything either. He still doesn't have a good case. Malice. On the first point, HHJ, it's recorded in the judgment at the end of paragraph 90 that one of the points made at the hearing, the first instance hearing, was that dominant and proper motive had already been signalled as being a dubious basis for malice, for a properly established defence of qualified privilege under the statute. And Mr. Justice Nicklin has now developed that line of thinking and decided in the HHJ associated case that misuse of occasion or dominant and proper motive is not a type of malice available to defeat the statute reporting privilege. That decision is at tab 17 of the authority. And it was handed down on the 24th of June of this year.
Do you know if there's a pending appeal or application for appeal?
No, there's not.
There is no, I think I've been told there isn't.
I'm sorry, my lord.
I think I've been told there isn't one. It's not just that we don't know,
No,
but
there isn't.
there's been a positive decision not to pursue an appeal.
Thank you. This was a judgment after a trial of various preliminary issues, including statutory qualified privilege and malice. It's a mammoth judgment. Unfortunately, we don't have to look at a great deal of it. For present purposes, obviously, we're looking at what he has to say about malice and section 15. And this starts at paragraph 352, which is page 532 of the bundle. And the judge starts with the familiar explanations of what malice is. He refers to Lord Hobhouse about dishonesty in Three Rivers. He then sets out a lengthy passage from the classic speech, Lord Diplock and Horrocks and Lowe. And at 356 turns to what is quite a long exposition of Qadir and what that has to say about malice. He notes at 359, page 535, having dismissed the qualified privilege defence, the issue of malice did not strictly arise from determination. So Mr. Justice Tugendhat's words on malice in Qadir were strictly speaking overturned, but the points had been fully argued and he gave his decisions. If we go through over on to 363, the judge picks out an important point from Qadir, where he says, importantly in my judgment, Mr. Justice Tugendhat held that Lord Diplock's formulation of malice from Horrocks and Lowe was not directly applicable in the present case. As he explained, that was because the statutory privileges, such as the reporting privilege we're dealing with, relied upon by the defendant are plainly accorded for occasions where the publisher need not be acting out of any duty or interest, and where the publisher is not required to have any belief in the truth or falsehood of the document of which he was publishing an extract. Lord Diplock referred in passing at 150 to the exceptional case where a person may be under a duty to pass on without endorsing defamatory reports made by some other person, but he did not refer to the occasions which are the norm, not the exception, in statutory privilege, where the publisher, being under no duty, chooses to pass on without endorsing defamatory statements in which he has no belief. In statutory privileges, it is the public interest that provides the basis of the legislative purpose, not the interests of the publisher, still less any duty of the publisher. So, obviously, Mr. Justice Tugendhat there is drawing a clear distinction between traditional qualified privilege, which is all about the relationship to the parties, and these statutory privileges, which are all about the public interest and passing on the important protected information to the public. After finishing his recitation of Qidiyya, Mr. Justice Nicklin at 366 says it's common ground between the parties. This is the first decision on the issue of malice in section 15 since Qidiyya. And the first in relation to section 6, though it's not relevant today. He says, in my judgment, this is 5 lines down, in my judgment it is important to give due weight to statutory qualified privilege, particularly where the statute grants a reporting privilege, because of the importance of Article 10. Like Tugendhat in Qidiyya, I am satisfied that the rationale for granting a reporting privilege is the importance attached to dissemination of the protected information. As Lord Esher observed in the underlying passage from Clark, the privilege is granted for some reason. When determining the scope of the privilege and the type of malice that could defeat it, the court must have this purpose well in mind. Over the page, at 368, in my view, some caution needs to be adopted in mapping across concepts that, whilst readily applicable to common law qualified privilege, do not find a ready analogue with instances of statutory privilege, particularly reporting privilege. Consistent with the underlying Article 10 rationale, it is difficult to talk about a reporting privilege being misused or for a defendant's motives in publication having any substantial bearing on this. Under Section 15(3) Defamation Act, a defendant's privilege defense would fail in respect of any publication that is not of public interest and not for the public benefit. If a defendant surmounts that hurdle and demonstrates that his or her publication is a fair and accurate report, copy, extract, or summary, one of the paragraphs of Schedule 1, the question is what state of mind should amount to malice so as to defeat such privilege. Whilst I can see that privilege could be rightly denied, where the defendant knew what he was publishing under a reporting privilege was false, or was reckless to a degree that he or she was treated as having this knowledge, the law does not require a positive belief in the truth of what's being reported. In many, if not most, reporting privilege cases, the defendant simply will not know whether the facts being reported are true or false. Reporting privilege exists to protect the publication of relevant facts, true or false. The journalist is essentially a conduit for passing on the important protected information. Their state of mind is irrelevant. There are various other passages in which the judge makes the same or similar points as he goes through the authorities. We have sidelined them. I don't know whether the court wants me to go through any more. Perhaps I'll move to the conclusion of this section of the judgment. At 377, page 540. Whilst honesty of belief is necessarily the touchstone for the honest opinion defence, that element is not and cannot be a prerequisite of a statutory reporting privilege. Often the reporter is in no position to know whether the facts are true or false, and it's not necessary to discharge the function of the privilege for him or her to know whether the allegations are true or false. In my judgment, once that important premise is recognised, the reasoning that compels the rejection of dominant improper purpose malice as a basis for defeating an honest opinion defence strongly supports a similar conclusion for statutory reporting privilege. Insofar as the claimant's malice plea depends upon proof of an alleged improper dominant motive of providing an endorsement of the allegations made against the claimant in the articles, I would hold that this was not a proper basis upon which an otherwise viable defence of statutory reporting privilege could be defeated. Proof of some private motivation, whether it be an attempt to secure some private advantage for the reporter, some disadvantage for the claimant, or even spite, and even if this is dominant or sole motivation for the publication of what has otherwise been held to be a fair and accurate report of information of public interest and published for the benefit of, this is the information that must mean the public, it is insufficient to defeat a statutory reporting privilege. In the perhaps unusual and rare case where the reporter knows that the facts facts in an otherwise fair and accurate report are nevertheless false, or is reckless to a degree that the law treats him or her as having such knowledge, then he or she would be malicious if they were presented to the readers as true or without suitable caveat. And then he goes on to say, but they might have other problems in that case, in any event. So we say that is a correct.
So it's difficult, isn't it, in the case? I'm just testing whether that reservation which Mr. Justice Nicklin makes is one he has to make. I forget now whether it was you or Mr. Speaker. I think it was you who made the point. Well, no, sorry, Mr. Speaker, that in fact, in a political context where a politician says something which is obviously a lie, which the reporter knows is a lie.
Yes.
The fact that it is made
Yes.
will itself often be very important, because people will say, I'm not going to vote for someone who tells obvious lies.
Yes.
In that situation, the reporter is reporting a lie.
Yes.
Do they have to caveat it in order to be safe from an allegation of malice? Or
No.
report the report?
I would submit not. No, I quite agree with your Lordship's point. I don't think, in fairness to Justice Nicklin, that he's giving an exhaustive count of all the exceptions.
And it's not, well, I don't know, we'll have to hear to what extent this is a relevant point for this case, but I was just testing whether, in fact, as I say, Mr. Justice Nicklin needed to make that reservation.
I think
you say he didn't.
He refers to presenting to readers as true or without suitable caveat. I think it could be summarised as improperly presenting the material.
Then it would be unfair.
Yes.
I find this quite difficult, this passage, because what does he mean by presenting it as true? If it's just a report and it's fair and accurate, doesn't adopt what's being alleged, then it will prima facie get privilege.
Yes.
But how can it simultaneously be fair and accurate and present as true?
He may be referring to, for example, what happened in Qadir, where there is a statement outside the privilege.
So what happened
In Qadir, there were two articles in Qadir. The first article in Qadir, it is a report of a particulars of claim, and the defendant came across it because at the end of the report it said that the parties declined to comment on the allegations. In fact, the claimant had filed a defence and was disputing the claim. So that was untrue. The judge said that the stating that he had declined to comment on the allegations led the reader to believe that he wasn't disputing them, when he was. That wasn't part of the report of the particulars of claim. It was an extraneous matter. So we would say that is an example of where it might be said that you are presenting the report as being true. You're doing something, it's the way that you're presenting the material. You're presenting the material in any way that endorses it or adds to it or gives it some sort of premature that it doesn't have already.
That's quite significant consequences, doesn't it? It suggests that if one reports a statement, a manifestly false statement, or a statement one knows to be false, made by someone on an occasion like this, without adding context, as I said, or without fact-checking it in some way, then you're liable to be found to be malicious.
Yes, it does suggest that. Earlier on in one of the passages, he refers to they could be malicious if they had knowledge of the falsity. And that may be a better way of putting it.
Yeah, I mean, your point is this isn't purporting to lay down a general rule of law, but a finding of malice would have to be made in any circumstance of that kind.
Yes, he's simply explaining that it is, well, firstly, he's making the point that it's going to be unusually rare that a reporter will know that the facts aren't true. Well, we know that the facts are false, but then he's allowing for the fact that they may be malicious in certain cases. We would certainly say, in a political context, it is going to be very difficult to suggest that it is malicious to report statements made by a senior politician. Absent some sort of context that indicates that those allegations are true.
And reporters do sometimes stick with overseas reporting, not to become too contentious, use formulas when reporting what it's pretty clear they believe to be lies by a prominent politician. Say something like, there is no evidence to support this.
Yes.
For example, we can all think of examples from overseas. If Mr. Justice Nicklin were in para 378 stating an absolute rule, which you're saying he wasn't, that's the kind of formula you'd have to do, really.
Yes.
And you'd then have to decide how often would you have to do it.
Yes. It's like rather difficult.
How obvious does a lie have to be?
Yes.
Yeah, okay, thank you.
It rather undermines the point that even Judge, His Honour Judge Lewis accepted, which is that the reporter of a political speech does not have to fact check. At the end of paragraph 83 of the judgment, he said the publisher of a fair and accurate report does not have to fact check what is said or trawl back through cuttings that
Yeah.
past the marks.
Okay, so that's Harkham.
That is Harkham. So we raised this point in our supplementary skeleton argument which the court gave us permission to file. And in response, the claimant's answer was, which is page 170 of the core bundle, if the court wants to turn it up. He said that that would have added nothing material to the decision made on Malice, because the respondent will have a case on Malice akin to those pursued successfully in Qiddiya. That's not right. The Malice cases in Qiddiya were very different. The first point to make, as Mr. Justice Nicklin's judgment indicated, is that the statements on Malice in Qiddiya were all opened because the defence failed in public interest public bad. But he did hear full argument and he did set out his decisions so far as he would have made them. There were two articles. I've referred to one already, where it was a report of a particulars of claim, and it contained the false statement at the end that the claimant had declined to comment on the allegations, when he had served an acknowledgement of service indicating an intention to dispute, and then he later served the defence.
Sorry, Mr. London, you're one row back and I'm getting old.
Sorry.
Can you speak up a bit?
So, there were two articles in Qiddiya. First article, report of a particulars of claim. Nothing wrong with the report itself, but at the end of the article, the journalist said that the parties had declined to comment on the allegations.
Yes.
Which the judge took to mean he wasn't disputing. In fact, he had already served an acknowledgement of service, indicating an intention to dispute the claim. Indeed, the particulars of claim would not have been opened for inspection had he not served.
Yes.
So he served his acknowledgement of service all along, and then he serves a defence, and that statement that he's declined to comment remains on the website. Judge finds that from the date that the journalist knew that he had served a defence, that rendered that statement that he had declined to comment
Yes.
so obviously unknowingly false that he was malicious. That can be found. The Qiddiya is tab 11 of the relevant bundle, and the relevant findings are on page 2812 of the bundle.
Yes.
Paragraph 224, well, the heading of this section at the top is the position after 17th June 2011, and that's when the defendant was found to be malicious. Paragraph 224, the plea in paras 11.5 and 11.6 is that ANL, the defendant, knew as from the 17th of June what it had already published and was continuing to publish online was false. It cannot be said of a defendant who has filed a defence that he has not commented upon the allegation in the claim. And this is the point that succeeds. The judge goes through the evidence, and essentially the journalist says Mail Online website is operated separately from the newspaper. I didn't feel I had any obligation to tell them, to give them any updates. Over the page at 230, the judge says, this does not establish what motive he may have had for doing nothing about the mistake he now knew he made. And as Mr. Warby has observed, an improper motive is not pleaded. Not apparent to me what motive Mr. Watkins may have had for doing nothing when something needed to be done, but in my judgment it was more than odd, it was recklessness on his part. I do not need to find out what his motive was. For whatever reason, he didn't care whether Mail Online continued to publish the first article in a form which, through want of responsible journalism, continued to state falsely that Mr. Gadir had made no comment on the allegations in the Penthouse claim. The plea of malice succeeds on this point for the period from 17th of June. So this was a statement outside the four square corners of the report about the response to the protected information. There is no equivalence in this case. All of the words complained of are simply a report of the Sharif's allegations. Indeed, the defendant was broadcasting on a daily basis rallies given by Imran Khan. And this is in the judgment. So the viewer who thinks, well, I wonder what the response is to these allegations, isn't going to have to wait to see the rallies given by the other side. And that's the nature of political debate. That was the first article in Gadir, so that's not akin to the facts that we have here. The second article in Gadir was a report of court proceedings, and they were unfair and misleading because the article failed to include exculpatory comments made by the judge during the hearing.
One view of it was that they deliberately excluded the exculpatory.
Yes, that's right. They were relying on they didn't attend the hearing, they relied on another report which included comments made by the judge which were exculpatory claimant. But when the Mail came to write the article, they did not include those. And the judge concluded at 252, looking at the evidence as a whole, again I find that Mr. Watkins was deliberately publishing a report that was unfair to Mr. Gadir in omitting to attribute to the judge the statement that Mr. Gadir did not lend any money. So omitting a key part of the proceeding, at least a key part as far as the claimant was concerned, and a key part in terms of maintaining a fair report in respect of his reputation. Again, there's no equivalence here. There's no suggestion there's any part of Ms. Sharif's speech which was in any way defending the claimant or Imran Khan for that matter. So the claimant's reliance on Gadir is a red herring. You say that
Can you just remind me why the report was fair and accurate, or whether
it wasn't. It wasn't.
So
because he was only dealing with malice on a.
okay. So it was unfair and inaccurate, and malicious because it was unfair
Yes.
and inaccurate. It's a long time ago.
I mean, he referred to this. He summarised the ways in which he had found these articles to be malicious. Paragraph 212,
Yeah.
which is a little earlier, page 279 at the bottom. He said, if the tests in the schedule to the 96 Act, fairness and accuracy, and public concern and public benefit, were satisfied in this case, contrary to what I have decided above, malice could be established in principle by proof that the defendant knew that the claim was disputed, but knowingly published the false statement that it was not, or knew that the form in which it reported the extract from the particulars of claim or in the case of the second article, the hearing was misleading or unfair. I quite agree, there is generally going to be a complete overlap between fairness and the report being malicious and misleading in this sense. But it is possible, I suppose, that one might somehow have a fair and accurate report, but nonetheless, due to the manner of presentation, misleading. But in any event, these facts are very far away from where we are with speech. So, we say to succeed, the claimant has to bring himself within hearkening and has to show actual knowledge of falsity on the part of the defendant. Actual knowledge of falsity and, as we say, improper presentation of material. Mr. Justice Nicklin observes this will be an unusual and rare case. The evidence, we say, doesn't support this.
We're now on your third point.
We're now on the third point.
Yes.
It's useful to go back to the actual allegations made that are complained of. The relevant part of the speech is set out in the judgment, paragraph 21. This is the conclusion of the Sharif's speech. And she says, as set out in 81, and finally, listen to me, I'm just about to end my speech. This tribulation also abuses the media which made him Imran Khan. The media which showed empty seats in the Jalsa day and night. The media which gave him one-sided coverage. Today, except for one media channel named ARY. Except for one media channel, he's gone after all the media channels, calls them traitors, calls them agents, calls them crowds. Do you know why he doesn't say anything to ARY? Just listen. ARY, who is attacking state institutions in collaboration with him. ARY, who is abusing state institutions when their anchors tweets. They and Imran Khan are like this. Shows her fingers together. Do you know why? Because Imran Khan's close friend, the owner of ARY, Salman Iqbal, a gold smuggler, Imran Khan gave him the benefit of 40 billion rupees. Imran Khan waived his 10 to 12 billion rupees of taxes. Imran Khan gave him 4 billion rupees world call without any due process. They're protecting each other because they are equal partners in the theft. He then goes on to say that Imran Khan is a name of chaos and so on. So the allegation generally about the claimant Imran Khan is a close and corrupt relationship. She makes specific points about him being a gold smuggler. She says that Khan gave him the benefit of 40 billion rupees. She says that Khan waived 10 to 12 billion rupees of taxes, and that Khan gave him 4 billion rupees world call without any due process. So what are the facts and matters relied on to show that the defendant had actual knowledge of the falsity of these allegations? The evidence comes from Mr. Yousaf, who is a journalist for ARY. Claimant himself doesn't give evidence. Mr. Yousaf's witness statement is in the supplementary bundle, tab 9. And the relevant section starts at page 61 of the bundle.
Page 91, did you say?
61.
61, thank you.
And this section is headed the defendant's broadcasts and what it must or should have known concerning this nuanced claims. That is equivocal, we say, and indicative of the fact that the evidence does not show actual knowledge of falsity.
Well, that's the heading only. I mean,
It is the heading. The general allegation of corruption, Mr. Yousaf addresses this at paragraph 29, page 62.
What about dealing with it in the order that the world call bit?
I was going to deal with them in the order
Okay, well,
the Mr.
yeah.
deals with them, if that's okay. I will come to world call. Paragraph 29, the gold smuggling and wider corruption allegations are just that, historic allegations going back more than 20 years, based on no credible evidence whatsoever, in respect of which both ARY and the claimant have issued public denials on multiple occasions. So one expects, let's see what these occasions are. Let's hear from the claimant as to his public denials. But there are none. There are no denials from the claimant at all in evidence, or referred to in any of these reports. This is a broad assertion that there have been denials, but even as an assertion, it doesn't really work, because the mere fact there have been denials doesn't mean that the reporter has to believe them and know the allegations are untrue. But in terms of corruption, there is nothing. There are no denials at all. The second allegation made by Ms. Sharif is that Mr. Khan is a gold smuggler. The only evidence about a denial on that is at paragraphs 30 to 31. At 30, Mr. Yousaf refers to Mr. Rana's witness statement for the defendant and refers to an article in the Washington Post on the 17th of February 2002 alleging that ARY traders, one part of the ARY group, so one ARY company, had transferred gold from Afghanistan to Dubai on behalf of the Taliban. Then on 31 says, however, Mr. Rana neglects to mention that Abdul Razak Yaqub, ARY's late owner and founder, is quoted in the article as stating that he imports and exports gold legally. Mr. Rana also fails to mention that ARY traders subsequently published a letter of response in the Washington Post on the 7th of March 2002, denying any involvement with the Taliban and indicating that it would give cooperation to an official inquiry. So this is an article and a letter in the Washington Post in 2002, 20 years before the speech given by Ms. Sharif. It has no mention of the claimant, no suggestion that he has denied anything. This is complete nonsense in terms of a suggestion or evidence or a case that the defendant would have known that the allegation of gold smuggling by the claimant was untrue, known as a fact. At paragraph 32, there is then a reference to a Hong Kong court decision in 2006, but the judge rightly dismisses this as being completely irrelevant in his judgment, because it was a decision about a Reynolds privilege defence, so it was a decision about whether the journalists had acted responsibly, and the meanings the article complained of was about money laundering, terrorist financing and drug trafficking, but not gold smuggling, or any of the allegations contained in this article. Paragraph 78 of the judgment, which Judge Riley begins, for some reason, the claimant's evidence included. The next allegation that Ms. Sharif makes is that Imran Khan had given the claimant the benefit of 40 billion rupees. There is nothing in the evidence or the case put forward about Malice about this at all. Nothing at all. No reason is advanced as to why they would have known that this was untrue.
Sorry, just before you leave the paragraph 78, so what does the judge say in relation to this?
Well, I think his comment really is in the first line, which is for some reason the claimant's evidence included. So he's recording the claimant's evidence included this decision.
And what about the last sentence of that paragraph?
Well, these are particular ARY companies who it said have assisted drug traffickers in laundering money by the export to them of gold, and the court finding there was no evidence supporting the allegation.
So, I mean, in paragraph 32, what the deponent has said, I don't know whether it's true or not, but obviously we're not at the stage of dealing with that, has said that the claimant gave evidence at the trial, and that the judgment afterwards, which was well publicised, said that there was no evidence to support the allegation of gold trading. So the inference that they seem to ask the courts to draw is that everyone must have known to repeat the allegation of gold trading was false.
Well, the allegation, the judgment records, this judgment records in that last sentence of paragraph 78, but what the Hong Kong judgment was addressing was an allegation that ARY had assisted drug traffickers in laundering their money by exporting to them gold.
Did the judge have anything more than we do?
We had the judgment at first instance.
When we don't.
We don't have it.
No, I couldn't find it.
No, I'm sorry. We can provide it to the court if that would assist. But the point is, this is not a sort of definitive, authoritative, forever rebuttal of the idea that Mr. Iqbal has smuggled gold at some point. No one knowing that 16 years earlier there had been a court case in Hong Kong in which one of the peripheral allegations had touched upon smuggling, and the court had said that allegation, there was no evidence to support it. That is not.
I think, as a matter of prudence, we ought to have the Hong Kong judgment before the judge, was it?
Yes, we can certainly send it to you.
Supply that over the adjournment.
Yes.
Ideally in hard copy, but if not, at least in e-copy.
Yes. The point is that is a particular set of ARY companies in a court case in Hong Kong.
Well, I dare say, but just so that we can understand how the judge dealt with it.
Yes. You say to say that these very old, very specific rebuttals or denials, insofar as there are any, cannot possibly be said to lead the reporter to know for sure that when Ms. Sharif speaks in 2022 about the relationship with Mr. Khan, which of course Imran Khan only came into power in 2018. So all of these reports from many years ago cannot possibly be relevant to the corrupt relationship which is alleged. The high point of the claimant's case is in respect of World Call, which Mr. Youssef deals with in paragraph 26. And what he says is, by May 2022, it's common knowledge the acquisition of World Call was not going ahead, and that Mr. Khan had not therefore given it away in exchange for the claimant's political support. ARY's withdrawal from the deal.
Where did you say 36?
26.
26.
Back at 26. Common knowledge that the acquisition wasn't going ahead, Mr. Khan hadn't therefore given it away. Now, Ms. Sharif's allegations were about the close and corrupt relationship between the Prime Minister and the claimant as the head of the ARY organisation. And one example was said to be helping Mr. Iqbal, the claimant, acquire World Call. The words in the judgment refer to giving it away, but nobody is suggesting it means he literally was giving it for free. The claimant's own pleaded meaning refers to being able to acquire it at an undervalue without due diligence. Assume for a moment that that's true, that there was a corrupt deal between Imran Khan and the claimant, whereby he was given this company at an undervalue. The fact that the deal ultimately doesn't go through, that ARY pull out of the deal, does not undermine the idea that there was corruption at the outset. It cannot possibly be said that ARY not going through with the deal means that there was never any corruption, and that the allegation of corruption is known to be untrue. It's as if, to put it in a UK comparison, it's as if a senior Labour figure has said that Boris Johnson has a corrupt relationship with Rupert Murdoch and has somehow arranged for him to acquire Channel 4 at an undervalue without due diligence. If a few months later Murdoch's company announced they're not going to go through with the deal, it does not mean there wasn't any corrupt dealings at the outset. Obviously, it's a development in the story.
Well, we have the point.
Thank you. So we say that is there's no basis for alleging knowledge of falsity, and even if there is, to go back to the point we looked at about Mr. Justice Nicklin's final paragraphs, even if there is, this has been presented as Ms. Sharif's allegations against Mr. Khan as part of a series of rallies, where Mr. Khan's rallies are also being reported. There is no endorsement, there's no indication that the words are true. Viewers would know they were getting one side of a political debate. We say that even if there could be some basis, which we say there clearly isn't, it's not improperly presented such as to give rise to a case of malice.
What do you say about the judge's paragraph 73? Which is where he said, look, I don't know the bottoms of it. You said, well, the judge has looked through the Hong Kong judgment and comes to some conclusion. We haven't looked through the Hong Kong judgment yet. But the judge, having looked through that and all the other bits, says there's a clear dispute about what the defendant knew or should have known.
Well, at 73, he's saying there's a dispute about what the defendant knew about knew or should have known that the allegations were disputed and or untrue.
Yeah.
What I'm saying is, the point is, the claimant has to have a case, a case with facts and matters to show why it is that the reporter would know these things are untrue. And as I've set out, there simply isn't one. There's no sensible basis on which you can say, well, several of the allegations there are no denials of at all. And to the extent that there are denials, they are relating to specific companies at a specific time, long in the past, not in relation to a corrupt relationship within the
Can I just put to you the bit that concerned me from the paragraph 26 and what the judge said and your comments on it? One of the allegations that Ms. Sharif made was world calls being given away for 4 billion rupees, effectively. And what is said, well, you knew it hadn't been given away. And that was well known because it was published in regulatory provisions. And therefore, when you started, not the first broadcast, but when you started to highlight that allegation later, you knew it was false. What's the answer to that?
Well, because I say the point is, it's the corruption. It's the corruption underpinning the deal, the prospective deal. The idea is that Khan has given the claimant an ability to acquire wealth. The fact that he doesn't go through with it doesn't mean that there isn't a corrupt relationship. It's in a series of statements about why there is a corrupt relationship. That is how I read it, that's how the claimant reads it, that's how the claimant pleads it in their defamatory meaning, pages 126 to 127. The fact that they ultimately chooses not to take advantage of it doesn't mean that there wasn't any corrupt act at the outset. It simply doesn't. It's a development in the story rather than something that means that there was never any wrongdoing at all. I see the time. I mean, if the court is against us on Harkham being the correct approach, then we will need to look at the other factors set forth by the claimant as being a basis for a dominant and proper purpose. I don't have time to go through them all, so I'm just going to have to summarise, which is that they are generally they are mere assertion, and they are not more consistent with malice than with its absence. The high point of their case is that the defendant has repeated, by including the in a report of mystery speech, this aspect, which as we see was the conclusion of her speech. It has repeated the allegation. Well, repeating an allegation, if it was honestly believed to be, if it was honestly believed the first time, if it was honestly and genuinely reported the first time, reporting it a second time doesn't make it malicious.
And the repetitions are in the immediate aftermath of the first.
Yes, just for a few hours overnight in the hourly headlines. To put a counterfactual, if the defendant really was malicious, he would have been bringing this up night after night, talking heads about it, etc.
Now, Mr. Bunn, we can't unfortunately sit for a few minutes longer over the break, so that essentially is your submission, is it?
Yes, those, as I say, the other factors do not add anything to the malice plea, to the knowledge of falsehood.
And if you think it's sufficiently important, you can take out of your reply a very few minutes after, at 2 o'clock.
Thank you.
Just to make the points that you haven't yet made. We'll sit again at 2.